In the last section, we talked about pleadings and the way that a lawsuit is filed and served on the parties. Once the pleadings have been served, there's a whole bunch of steps that have to take place before we actually get to a trial. And the first is what we call discovery. And this is where each side has to share all of the evidence that they have that relates to the issues of the case. There are, of course, exceptions for privilege, but that's outside of the scope of this course. Once all of the parties have shared their documents with one another, they have the opportunity to scrutinize that evidence through a process called examination for discovery. We probably have seen this a lot on American television when we see depositions. It's the same thing. This is just our term for it here in Alberta, is when a witness who submitted the evidence is questioned under oath about that evidence. But usually this takes place in a boardroom and not a courtroom. Oftentimes, once the examinations for discovery are complete, the parties have a good idea of where they stand and the evidence available that they can facilitate settlement. And settlement occurs when the parties agree to resolve their dispute outside of court and end the case right there, usually with a contracted settlement agreement outlining what everybody is going to do. Absent settlement after an examination for discovery, many jurisdictions have a mandatory step of a pretrial conference. And a pretrial conference is a meeting between the parties, which are the plaintiff and the defendant and their lawyers if applicable, where they'll outline their case for the judge, and the judge will give them their opinion on where they think things are headed. And this can be really valuable because obviously a judge is an expert in the area and their opinion is going to carry a lot of weight. Typically, the person who is projected to be the losing party will be inspired to settle after the pretrial conference, which is really the aim of it, to save everybody a whole bunch of time and money. Alternatively, or sometimes in addition to a pretrial conference, parties can have a mediation. And a mediation is a little bit different than a pretrial conference because it's not with a judge, it's with a certified mediator who is a person who is trained on conflict resolution, who tries to help the parties understand one another's interests and come to a compromise, again, to resolve and settle the case. That a mediator does not actually decide which party they agree with. They try and help the parties come to an agreement together. On the other hand, an arbitrator can make a decision between the parties. So an arbitration is similar to a mediation, but instead of a mediator, you have an arbitrator, and the arbitrator makes a decision about who they agree with, and that is binding on the parties. In general, one of these pre-trial activities is usually preferred as a way to settle a case as opposed to the trial. And it allows parties to resolve disputes while the evidence is still fresh and, move on with their lives afterwards. Of course, if they attempt all of these pretrial activities and none are successful, then they would simply wait for trial and a judge or judge and jury would ultimately make the decision.